Welcome to Cordell and Cordell's Men's Divorce Podcast, moderated by Managing Partner and CEO Scott Trout, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hey, welcome back. It's the Men's Divorce Podcast. I'm Scott Trout, Managing Partner, CEO of Cordell and Cordell. And as always, we want to bring you the latest information, topics, things that you need to know to kind of further educate yourself. And obviously, it's not legal advice. We can't do that without a consultation. And you can do that by going to cordell.com, and you can schedule a consultation right on the homepage there. You enter your zip code, it'll locate the office closest to you, and you can do that without even picking up the phone. Or you can call us at 866-DADS-LAW, and you can schedule that. You can do it on the phone, in person, via Zoom, whatever is convenient for you. Also, check out the Men's Divorce Podcast Live. That's happening every month, where we bring in someone, a party, a panelist, to talk about topics. You can ask questions live and get answers right then and right there. We just had our Men's Divorce Podcast Live, where we talked about taxes, tax issues in divorce. If it interests you, check it out. It'll be on our YouTube channel. You can check out that as well as all of our other previous podcasts and Podcast Live. So let's get to it. Lauren, welcome back to the program. How are you?
Yeah, I'm wonderful, and happy Friday.
Yeah, exactly. All right, let's get to it. This is a really interesting topic. Why even bother with a lawyer? Why a divorce lawyer on top of that? And that's always the big question, because, everybody has a friend perhaps, or someone they know, a friend of a friend who's gone through divorce, and they think, I can do it myself. Why can I represent myself? That's the first question.
And technically, yes, you can. But whether or not that's a wise choice, most likely it's not. So if somebody's choosing to represent themselves, the term that we call it in court is called you're representing yourself pro se. And so you'll often hear people say, a man who is his own lawyer has a fool for a client. And the reason for that being is many, as we'll discuss here in this podcast today. But generally, self-represented litigants are treated as if they know the law just as much as a lawyer. They're going to be held to the same standard. And I don't know is not going to be an excuse that's going to fly in court. Yeah. So you got to know the law, rules of evidence, what your remedies are, and you're held to the same standard.
And it's absolute. You think, ask a lawyer. Most of the time, I would hope, they don't represent themselves either. I'm fully capable. I had a dispute with someone in a building in which we have a tenant, and I thought, I'm going to have to hire a lawyer. I know I could do it myself, but again, sometimes you get too close to it. Doctors don't treat themselves. It is what it is. And I think, especially if you go in pro se and you don't have that legal training, I personally tend to see judges get irritated. I think they are irritated because you don't know the functions, the administrative procedures, how courtroom works, the decorum, the objections, what forms to fill out. And they get very, very frustrated, and it shows in their rulings towards pro se litigants and their treatment. So it may not be fair or right, but that's just the way that judges really treat litigants who represent themselves in the pro se world. So it is one of those things which, okay, Lauren, I'm convinced that I shouldn't represent myself. What are the advantages of hiring a lawyer? Tell me why. Convince me.
All right. Well, so we handle the day-to-day complexities and so that allows you to focus on your life. So especially in more contested cases, or even not. So keeping track of what all the assets and liabilities are, and getting all the documents packaged together and in the right format. And sometimes we get emails from opposing counsel needing immediate attention. And so we're, schedules accommodating, we're able to handle that. And if there's emergency hearings, then okay, we can pop into court, whereas you might not be able to necessarily. So we're able to handle some of those complexities and help break it down. We're also here to help you think about the case from a legal perspective rather than an emotional perspective. So things where, you see, oh, hey, they're making all these requests and how dare they, and so forth. We're like, okay, well, this is how the law treats the issue, and able to de-escalate the situation and help you process that as well. We can help you strategize and gather evidence. So again, you might not know what's important for the judge. You might be focusing on, again, an emotional detail about something where it's like, okay, well, I know how the judge thinks about this particular issue, and maybe that aspect of your case may not be as important, but let's focus on this area and be talking about, hey, here's different things that you should be gathering. Hey, let's look at historical financial records. Let's look at text messages relating to these particular issues. Oh, maybe we should go consult an expert on this issue and try to get them to issue an opinion in your case. So we can help you strategize and develop the evidence that the judge actually needs to hear. And again, sometimes people think, oh, if I'm going to be getting a lawyer, that this is going to be highly contentious and litigious. That's not necessarily our goal. If we can settle a case and try to save parties' attorney's fees, we are more than happy to settle. But you don't want to put all your eggs in one basket thinking that you are going to settle, because there's no guarantee that you're going to settle.
Right.
And you got to be ready to go to court. It puts you in a really bad negotiating position if you're not ready to go to court. If
Right.
you're to go to court, then you're probably going to settle on stuff that you probably shouldn't.
And you mentioned, the whole idea of high cost litigation. I mean, there's this theory that every lawyer that someone hires, that all they want to do is continue to get to trial just so they can have more fees. But I mean, I think if you find the right lawyer, or, like me, I'm outcome driven, meaning that if my client says, I want A, B, or C, that's what I'm driven by. And no matter what it is, if I finish it in a month or in a year, and as long as the client's goals, that's whatever their goals are, and they change. And I think that's maybe a fair question when you're looking for lawyers. Are you outcome driven? What does that mean? And have that discussion. But, a lot of clients or, and many of you out there who are thinking, okay, I get it, but what if I want to do it myself? Is there any self-help available? And I know, for example, here in the county of St. Louis, there are court employees whose duties are to assist pro se litigants, because there's a special docket for pro se here in St. Louis County. So are there any other self-help remedies that people listening or watching should be thinking about?
Yeah. And so that's interesting that you have that in St. Louis. So in Texas, that might be considered unauthorized practice of law. So the court employees are not able to help you actually fill out the forms. They might say, hey, here's some forms that are available in the law library, but they're not going to be able to help you fill out and answer questions about how to fill out these forms. Or Texas, they do have, the state bar does, again, have some of these fill in the blank forms, a limited selection, but they do have some available for pro se litigants, but they're cookie cutter and they're not necessarily going to apply to your case. There might be other items of relief that you might want to seek in pleadings of your own. But again, this circles back to, you don't know what you don't know. So you might not know that these remedies are available, or that you need to specifically ask for certain requests in your pleadings before going to court. And sometimes, again, these documents, they're not going to cover everything, and you don't necessarily know how to draft in a way that a lawyer knows how to draft things so that they're specific and enforceable. And I have people come to me a lot of times after the fact where they did these pro se forms, and it's a lot more expensive to try to fix it if you can, rather than if you had hired a lawyer the first time.
The internet's a good thing and it's a bad thing when it comes to finding forms, because good thing is there's a lot of information. The bad thing is there's a lot of old information that's out of date, and the forms are very insufficient. And as you suggest, they're incomplete, and they may or may not be sufficient when it comes to particular local rules. And that's huge. But then there's the new onset of my favorite, Chat GPT, right?
Yes. There's been lots of news stories about that, and some lawyers have actually gotten in trouble for trying to, cut some corners and use Chat GPT to do legal research in cases and submitting them as briefs to the court. And part of the problem with Chat GPT, so basically, people have been using them to try to create legal documents, but Chat GPT doesn't actually look at legal cases. They have prepared things that look like they might be real, so they kind of follow the same format and use some of the same vocabulary, but it's not actual cases. And so there have been cases where the appellate courts have sanctioned these attorneys for trying to rely on Chat GPT for citing false cases that were just made up. So please don't rely on Chat GPT or AI documents, at least not at this point. So.
Yeah. Chat GPT, it's interesting. It's proceed with caution as with anything. And so, I have many of occasions where a client comes in, says, look, we're going to agree, and it should be pretty easy. Can we just use one lawyer? And, that's always the hair on my neck, not on my head, since I don't have any, stands up. And so why not? Can they not just have one lawyer?
Well, so attorney ethical rules, technically in a divorce, even though you guys might be agreed in theory about the actual divorce, again, you guys are technically opposing parties in this divorce. Attorneys ethically can only represent one client. So if there's only going to be one attorney in a case, you should definitely be the one with the attorney and not the one without. And the reason for that being, again, attorneys' duties we're beholden to our client. So we're going to be drafting a decree in the manner that benefits our client the best and advising our client in the manner that benefits our client the best. And I'm not going to be trying to help out the opposing party. And I've had it again where people come to me after the fact saying, well, my spouse, they told me they weren't trying to mess me up. But again, it's, you don't know what you don't know. And so you might not realize that the attorney was drafting in a way that benefited their client the best. The client didn't know, oh, well, I wasn't trying to mess them up, but now it's after the fact and it's beneficial to me and I'm not going to worry about it now. Sorry about you. And so if you're going to have one attorney, be the person with the attorney and don't be without, because again, it's very important that the decree or court order or whatever it is that you have is drafted in your favor to the extent possible.
Yeah. I even go to the extent of when the client says, well, I'm going to have her come in and sign all the paperwork. I won't do it. And she's going to have to go sign somewhere else. Mm-hmm. I just don't ever want to give the impression that I've influenced someone unrepresented. Right. It's possible. So here's the thing. The takeaway from this is have a conversation with the lawyer you're meeting with and find the proper way to accomplish that goal and to make sure that if you want to use one, you can use one. But it's important you kind of think through all these questions is, okay, why is it so important, Lauren? Why are we talking so much? Why is it important to get this done the way you say we should get it done?
Well, so orders are orders. And again, ignorance of the law is not going to be an excuse to try to get a do-over. So for example, property division, you can't modify orders related to property division. So again, if you have the opportunity to be seeking out information and you find out after the fact, oh, I thought my spouse's retirement was worth X, but it's actually worth a lot more. Well, you don't get to go back in court to modify the property division. Or I've had people where they draft orders regarding sale of property and leave out requirements to actually refinance mortgages, or they leave the language too loose and it's not enforceable. And so then you're kind of stuck. So property division cannot be modified. And so you really want to make sure that it's done right the first time.
Yeah.
And then with parenting plans, again, it's not so simple as, oh, hey, I didn't realize, hey, these orders aren't fair. So while parenting plans, they can be modified, you still have to meet legal grounds to modify. So generally speaking, at least the legal standard in Texas, the primary one, if we're looking to modify a parenting plan, is that what your requests are in the best interest of the child, plus that there has been a material and substantial change in circumstances since the time of the prior order that had been contemplated at the time of the prior order. So not, oh, hey, I didn't know I could have asked for more time, or, oh, I just didn't want to fight right now. I just kind of wanted to throw my hands up in the air. I didn't have money for an attorney. I just wanted out.
It is the idea to fix something it's so hard, so expensive, and maybe even impossible. Because, at the end, after you've done some of these things, rather than taking the time to ensure that you're taking the path that is the right one for you and probably the most appropriate, which includes being represented, it's crazy.
Mm-hmm. Yeah, absolutely. And so you just really want to make sure that it's done right the first time. And it's not just the orders. Again, if this ends up contested, you're looking at, all right, how am I able to get in evidence properly in court? You might have all the evidence in the world, but if you don't know how to get it in front of the judge so that the judge can actually look at it, your hands are going to be tied. Or same deal, I've seen where self-represented litigants, the opposing counsel is just walking all over them, getting in evidence that probably shouldn't come in.
Right.
But they don't know to object.
If anybody wants to question whether they should represent themselves, I should suggest that they go watch the criminal trial of the defendant in Wisconsin. I can't remember his name, but he was tried and then convicted of running people over at some Christmas parade. He decided to represent himself, and it was a train wreck. And if you ever think that's the right thing to do, watch that trial, or just watch 1 or 2 days of the trial and see how the judge is really not happy, the fact that he's representing himself. But he's doing everything so wrong that he's limiting his appellate rights. He's missing out on witnesses because he couldn't figure out how to get them subpoenaed and when they should be there and the proper procedure. And she says, I'm not here to educate you on the law. I'm not going to instruct you on the proper way to do it. If you want to learn to do it, go hire a lawyer or go figure it out. And I can't remember his name, but it is worth a watch, and you'll realize that is not for me.
Right. And you picked up on a good topic too, waiver of appellate rights too. So again, if you're going to be making those arguments, you need to have the proper pleadings on file. You need to know how to get the evidence in. You need to know the proper objections. Again, I've had cases where people come to me after the fact saying, hey, can I appeal this? And if you don't make the information known timely while things are in there, again, your options are limited. So it's very important.
Well, Lauren, great stuff. Hopefully no one decides to hire themselves and they follow your advice. But if you want more information, contact Lauren. You can go to the website. You can go to cordell.com. You can schedule a consult just like this, or on the phone or in person. She can explain to you more about why you should not represent yourself, why you should hire Cordell and Cordell. You can check it out. Go to the website again. Lauren, thanks for joining today. Appreciate it.
Thanks for having me.
Check us out on YouTube. Also, check out our new Men's Divorce Podcast live. This is the Men's Divorce Podcast and Cordell, but we have a live version that you want to show up for and ask questions. It's free. All you have to do is register, show up, and it's usually 30 minutes during the day. It's excellent. We have really great guests, as well as an attorney or a panel of Cordell and Cordell attorneys to help guide you and give you questions in real time. So we'll have one coming up in November. You can check out all of our social media. You'll get information on that, or go to the website, cordell.com. Also, mensdivorce.com. You can check out all of our resources there as well. So until next time, have a great week.